Welcome to this presentation on 17A Guardianship, the impact on people with intellectual and developmental disabilities. Person-centered services provides health home care coordination for over 17,800 people with intellectual and developmental disabilities in 18 counties reaching throughout Western New York, Finger Lakes, and the Southern Tier regions. At Person-centered services, we start all our presentations with our mission, vision, and values. Our mission is to connect people to the care, support, and opportunities that maximize their quality of life. Vision, a community where all people lead fulfilling lives, and core values are people, integrity, and trust. My name is Craig Menig. I'm the Member Relations Manager. I'm also a supported decision-making facilitator and mentor. Here is my contact information. I can be reached at either email. So if you have any questions about what we do in member relations, you can contact me there. Some housekeeping. You may see that many of your cameras and microphones are turned off. That is just to reduce distractions during the presentation. We have a lot of people registered for this presentation, and I'm very excited about it, as I'm sure you are. You can put your questions in the chat. I will be here to monitor the chat for the questions, and we'll get those questions to our presenter at the end. Stella Dupree is our member relations specialist. She is also here, and she will monitor the chat as well. So, our presenter, Kim Weisbeck, is a supervising attorney in the Rochester office of Disability Rights New York in the Protection and Advocacy Program representing individuals with intellectual and developmental disabilities, also known as the PAD project. The PAD program provides legal representation and support for individuals with intellectual and/or developmental disabilities in pursuing legal and administrative remedies in matters pertaining to civil rights, discrimination, access to services, and special education law. Kim supervises the PAD team's guardianship practice, including the representation of people who are opposing guardianship or seeking to terminate guardianship, as well as systemic litigation and statewide collaboration with agencies to oppose system-wide violations of the constitutional rights of individuals facing and living under guardianship. She is a graduate of St. Lawrence University and Albany Law School, and prior to joining the DRNY, she engaged in private practice representing children and adults in Supreme and family courts. Kim is a past recipient of the Boyle Award for Child Advocacy and the Honorable Michael F. Dillon AFC Award. So, with that, Kim, I'm going to turn it over to you.
Thanks, Craig. I am not seeing my shared screen right now.
You'll probably have to reshare it. I think you stopped sharing when
I see. Okay. All right. Let's see here. Okay. Can you see my screen now?
Yep.
Okay, great.
Good to go.
Hi, everyone. I first would like to thank you for having me here, and I'm really looking forward to this presentation. It contains a lot of information. I'm hoping to have plenty of time at the end to answer questions. If we do run out of time, my contact information is on one of the slides at the end, and I am happy to have conversations via email after the presentation or at some point in the future. So I'm here today to talk about 17A guardianships, the impacts of guardianship, alternatives to guardianship, and supported decision-making in particular as one of the alternatives to guardianship. I'm also going to talk a little bit about the process of going through a termination proceeding for people who are living under guardianship. Just a little bit about Disability Rights New York. We are the statewide protection and advocacy system and the client assistance program in New York State. So we are an independent agency. We advocate for New Yorkers with disabilities to exercise their own life choices, to fully participate in their communities, and to protect and enforce individuals' civil and legal rights. As Craig said, I work in the PAD program. And so I specifically represent people with developmental disabilities, and I do supervise a team of advocates and attorneys who work for people with developmental disabilities. So DRNY provides information and referrals to individual clients and their family members who contact us on their behalf, and service providers who contact us on their behalf. We pursue legal, administrative, and other remedies and approaches for both individuals and classes of individuals. We work to educate policymakers. We establish goals and priorities every year for our programs. And, we coordinate and collaborate with other advocacy agencies. We have a lot of access authority to monitor and investigate abuse and neglect, including visiting provider sites, interviewing service recipients, interviewing service provider staff, reviewing individual records and records of investigations by other agencies such as the Justice Center. So we don't just do guardianship, we do a lot of other things. But today I'm here to talk about 17A guardianship. So what is 17A guardianship and what does it do? 17A guardianship is granted by the surrogates courts in New York State. And an important thing to know about it is that it is plenary in nature. That means that it strips the individual of all of their independent decision-making abilities and their legal personhood. Under New York State law, as it's currently written, a judge doesn't have the authority under the statute to tailor a 17A guardianship and make it just about the needs of the individual. It covers all decision making. And what it really does is it inserts a substituted decision maker for the individual with a disability. So do people lose their rights under guardianship? Yes. The simple answer is yes, they do. They lose their decision-making rights, which might include the right to decide where they live, the right to decide who to associate with, like friends or family members, the right to marry without a court intervention, the right to have children, the right to vote independently, the right to decide how money is spent, the right to decide on their education, the right to decide on what services are provided to that individual. Those are all things that are lost when a person lives under guardianship. And of course, a person living under guardianship has a say in what all of those decisions are. But at the end of the day, the guardian has the ultimate right to make the decisions. And I guess I want to be clear from the get-go. I want to be clear that there are a lot of people who need and benefit from a 17A guardianship. So I'm not here to say that 17A guardianship should not exist, but I am here to say that not everyone with a developmental disability needs a 17A guardianship, and not everyone who's currently living under guardianship needs that restrictive level of intervention. So why do people seek 17A guardianships over people with disabilities? There's a lot of traditional misconceptions about 17A guardianship. Often family members will seek guardianship because they believe that the guardianship is going to keep a person safe. They believe that a guardianship is going to keep a person out of trouble. They believe that a 17A guardianship is needed to be able to help people make decisions, because there's another misconception that a person with a disability simply isn't capable of making adult decisions alone. Sometimes a person living in a group home, their family members are told, or an IRA, that they need a guardianship. And sometimes that is because of agency convenience. It's simply easier for a provider agency to know that they have someone that they can go to sign papers. And also, of course, there is that desire to protect. So a family member who has a loved one living in an IRA might believe that they need a 17A guardianship to protect their loved one from harm at the hands of others. So what's really the problem with the 17A guardianship? One, as I said earlier, guardians are substitute decision makers. So they will, sometimes that undermines the independence and the autonomy of people with developmental, cognitive, or intellectual disabilities. People without guardians can participate more fully in their own life and also in their community by retaining or regaining that autonomy and being able to make their own decisions. 17A guardianship, as I said, is often a lot more restrictive than a person actually needs, and sometimes conflicts with guardians over the course of time, and that imbalance of power can lead to strained family relationships. So I talked about what guardianship does and what the impact of it can be on the person living under guardianship, but here's some things that guardianship actually can't do. It can't actually control the relationships that a person living under guardianship engages in. It can't actually control opinions. It can't actually control negative behaviors that are related to a person's disability or not. And at the end of the day, it really can't keep a person safe because a guardianship is a piece of paper and it can't actually control what happens in a person's day-to-day life. So in my practice, I represent people, and my team of attorneys and advocates represents people who are both facing guardianship and also people who are living under guardianship and they've decided that they don't want to and they don't need a guardianship any longer. And what we've learned over the course of the last, I've been working for DRNY for 8 years, almost 9 years now. And over the course of time, we've realized that there are a lot of shortcomings in the process of imposing a 17A guardianship. And it's really a problem with the way that the law is written and the way that it is imposed upon people during the process of guardianship. So what we've seen is there's really a failure to include the individual in the process. A person who is facing guardianship doesn't get adequate notice often or an explanation of what guardianship really is. Often someone comes to court or is brought to court and they're told by the judge that there's someone here who often a family member, sometimes an agency, they want to help you make decisions and protect your benefits. Is that something that sounds good to you? And yeah, I mean, of course it sounds good, but there's not an explanation of what the entire impact on a person's life is. And part of the problem is that there's no attorney who is assigned to represent a person facing guardianship. There's no right to counsel, even though a person facing guardianship is facing losing constitutional rights and freedoms that in other cases, in other courts, an attorney would be always assigned to represent someone, such as in a criminal proceeding where a person's the same constitutional rights are impacted, that person would have the right to counsel. But a person who's facing 17A guardianship in surrogates court does not have the right to have an attorney assigned to represent them. During the course of the court proceeding, the judge relies on hearsay, which is out of court statements, and there's a lack of actual hearings with witnesses where the person facing guardianship can meaningfully participate. So usually in New York State, a 17A guardianship is granted by a judge after the judge receives a petition that says why the person wants 17A guardianship. And usually the reason that a person is petitioning for 17A guardianship, they say that they want to help their loved one make decisions. They want to continue to help them and keep them safe. And that's usually the reason stated in the petition. And then the petition needs to be accompanied by 2 different medical certifications. And those medical certifications need to be prepared by a doctor or a licensed psychologist. And sometimes those medical certifications are prepared by doctors who haven't actually done an assessment of the individual facing guardianship, and they are simply relying on sometimes really outdated and inadequate evaluations. And I have represented people who are in their 20s and their 30s and their 40s and sometimes their 50s who are trying to terminate a guardianship that was imposed maybe when they were in their 18, 19, early 20s. But sometimes we've seen in the medical certifications, the evaluations that judges relied upon were conducted when that person was 8, 9, 10, 12 years old. So really old information. Another shortcoming of the process is that once a guardianship is imposed by the surrogates court, there's no follow-up. There's no requirement that the guardian file a report annually to let the court know of how things are going. How are they spending the time with the person who is now living under guardianship? They're also known as the ward. How are decisions being made? What kind of issues have come up? What kind of services have they decided that their ward is going to be receiving? Where's that person living? There's no follow-up with the court. So that guardianship really becomes lost. And what we've seen is that over time, sometimes guardians are become sick, they become elderly. We have represented clients whose guardians are gone and haven't had contact with them in years. And we've also represented people whose guardians are deceased, unfortunately. And even though the guardian is deceased, the guardianship continues. So there's a person who's been found to lack capacity, even though, as I've said, those medical certifications have often inadequate evaluations, and there's really not actually an assessment of someone's actual capacity before imposing the guardianship. But since the guardianship continues, there's a person living under guardianship who can't make their own decisions, but there's no one available to make their decisions for them because their guardian is no longer there. So there really are a lot of problems with the system. So I think there's some self-advocates here in the audience. So I just wanted to include this slide about how to protect yourself from guardianship. And if you're a person who doesn't currently live under guardianship, anyone with a developmental disability could have a petition filed against them in the future, alleging that they do need a guardian. So one of the things we always tell people is to talk to your medical providers now. Put it in writing to your doctor that you don't consent with them sharing your medical information for purposes of guardianship. That doesn't mean that you can't consent to have your medical information shared with a loved one for purposes of helping you make decisions, but you don't have to consent to your medical information being used in order to have a guardianship imposed. And you also should look at and update your HIPAA release form that you have on file with your doctor, assuming you have one. And if you don't, you can always ask your doctor to execute a HIPAA release form to narrow down who you want your records shared with and for what purpose. And you can write on that form that you do not consent to your records being shared for purposes of guardianship. You also can execute a healthcare proxy, and that can help. That is considered an alternative to guardianship when used with other supports. So you can decide now who you want to help you make decisions or to make decisions on your behalf in the future when a doctor finds that you now lack capacity because of illness or age to make those decisions. You can also consider a supported decision-making agreement, and I'm going to talk a lot more about supported decision-making agreements a little later on in my presentation, and consider a power of attorney form. So Some people come to us often and they want to terminate their guardianship. Real quick, a person who's living under guardianship according to the law has the right to file a petition to have their guardianship dissolved. And even a person who's living under guardianship and has been found to lack capacity still has that right under the law to challenge the guardianship. So the steps that one would take would be one, to contact an attorney, such as Disability Rights New York. Or if an individual lives in an IRA, Mental Hygiene Legal Services also will represent people who want to terminate their guardianships. And sometimes private attorneys will take on this role also. So a local bar association could be contacted. Next step after you contact an attorney is to get your court records from your original guardianship proceeding. Then you think about who would be a good witness for me, who would support me, and who are the people who are part of my support system who could come to court and show the court that I don't need, help me show the court that I don't need a guardian. Always consider having an evaluation done, and that is a conversation that one could have with their attorney to talk about the pros and cons of having an evaluation. And often having a psychological or a psychosocial evaluation can help. When a person wants to terminate their guardianship, a capacity assessment that is done by a provider agency can also help. Always consider the family impacts and the fact that when a person is filing to terminate their guardianship, the guardian will and must find out about that proceeding. So that's a conversation to have if your guardian is a family member, to let them know how you're feeling about the guardianship, and always be prepared to go to court. So when you're terminating a guardianship, as I said, the guardian always will be notified. So it's something important to think about because it often involves having a difficult conversation with your guardian, to let them know that you want to file something to terminate the guardianship. Now, often I have had many clients whose guardian is completely supportive of terminating the guardianship because there's a recognition that maybe when they first got the guardianship, they thought that that was what they were supposed to do, and that that was the logical next step when their loved one with a disability was reaching adulthood. And now there's an understanding that, of course, you don't have to file for guardianship just because your loved one is turning 18 or turning 19 and graduating and leaving high school. So there's a recognition that it's not necessary, and it probably wasn't necessary to begin with. And so often our clients come to us with the support of their guardians, and it makes the process a lot easier to remove the guardianship. When you go to court to remove your guardianship, the judge has to consider what less restrictive alternatives to guardianship there are. And that is also a rule that judges are supposed to follow when they're deciding whether or not to impose a guardianship, that they need to think about less restrictive alternatives before deciding to impose a guardianship. Some examples of those less restrictive alternatives, and I'll get into them later in the presentation: supported decision-making, family supports, and also what types of services a person is receiving through a PWDD and provider agencies. So decision-making alternatives for adults with developmental disabilities. Big one, supported decision-making. So this slide contains a quote from Kristen Booth Glenn, who was really the founder of Supported Decision Making New York. Supported Decision Making New York was a pilot program, and I know that Craig was involved with Supported Decision Making New York, and they really started the supported decision making movement in New York State. And Kristen Booth Glenn was instrumental in that. And this quote, I think, is just really important to remember, that at its simplest, our personhood is the consequences of all the decisions we've made over our lives. And everyone becomes something or someone because of the choices that they make. And supported decision making is really a program that recognizes and respects a person's autonomy and the right to make their decisions. So the difference between guardianship and supported decision making is really that guardianship is substituted decision making. So the right to make decisions is taken away from that individual, whereas supported decision making recognizes that there's a series of relationships and practices and arrangements and agreements that can be formal or informal that help a person through communication make decisions. So kind of some nuts and bolts of supported decision making. The person with a disability is referred to as a decision maker or a DM. Throughout the process, decision makers retain their autonomy and their civil rights. The decision makers choose what decisions they want help with and who the people are who will help them make those decisions. And those people are called their supporters. And then the decision maker and the supporters work together with a facilitator to develop the supported decision making agreement. And the supported decision making agreement spells out who provides help with what types of decisions and how those decisions will be made. Participation in a supported decision making agreement process is entirely voluntary, and the decision maker can change or terminate the agreement, but it's important to remember that a supporter may not do that. So throughout the whole time, the decision maker always retains the right to make their own decisions, to change the agreement, to end the agreement, to remove or change supporters at any time. So I have the website here, supporteddecisionmakingnewyork.org. It's important to note that there's been a lot of changes recently with the supported decision-making agreement system. It's kind of in a state of transition right now, but that website is still up and running and it still contains information. In July of 2023, Article 82 of the Mental Hygiene Law was enacted, and this recognizes under law the power of supported decision-making agreements, recognizes supported decision-making agreements as a less restrictive alternative to guardianship, and prevents discrimination by requiring third parties to accept the decisions that are made by people with supported decision-making agreements. And it really incentivizes courts and parents to consider and hopefully choose supported decision-making as an alternative to guardianship. This slide says that in September of 2025, OPWDD released regulations for supported decision-making. I realized that I made an error in that, and it was actually the end of August that those regulations were released, but the regulations are what they are. And what they are is the set of rules that kind of determines how the supported decision-making program is going to be applied from here on out. So there's going to be a new agency administering the supported decision-making agreements. OPWDD has not officially announced who that agency is. So that has resulted in a delay in starting up new agreements. Hopefully a new agency is going to be up and running very soon. Anyone who is something important to know about these regulations and the law, anyone who's not living under guardianship can sign a facilitated supported decision-making agreement, and it's legally recognized. So once the new agency is up and running, they're going to be working with decision makers and with supporters again, just as Supported Decision-Making New York was, and they'll be creating facilitated supported decision-making agreements that are going to be legally recognized. Anyone living under guardianship can still have a supported decision-making agreement, but it might not be legally recognized because they might not be able to complete a facilitated process while living under guardianship. Now, that is still not to say that a person can't have, anyone living under guardianship or not can have an informal supported decision-making agreement executed, and they can create one themselves with their supporters and sign it that would not be a legally recognized contract like a facilitated supported decision-making agreement would be, but it still is something that would have to be recognized by the court and considered by the court when considering it, whether guardianship is appropriate for a person. So there's other alternatives to 17A guardianship. And usually we find that people file for 17A guardianship for one of two reasons. One is they want to help their loved one make decisions regarding money. And so there's a lot of different alternatives to guardianship that a person with a disability and their supporters could benefit from. One is simply a joint bank account. You and someone that you choose open up a bank account together. Both of you put money in and take money out, and the other person can help you keep track of your money and help with repeating payments like rent or insurance. Another alternative is a power of attorney. That's a legal document that gives someone you choose the ability to make certain types of decisions for you. They only have the right to make the specific decisions that you pick and write into the document. And the document, the power of attorney form, can be terminated at any time. The power of the agent, and that's the person who has the authority to make the decisions, can be really broad or can be really narrow. They can be effective now or upon the happening of some future event, such as incapacity. And that really depends on what type of power of attorney form is filled out. Another way of helping people manage their money is through an ABLE account. In an ABLE account, the earnings are tax deferred and they're tax free so long as they're used for a qualified disability related expense. And that's really anything related to the disability and are for the benefit of maintaining or improving a person's health, their independence, or their quality of life. The money from an ABLE account can be spent by debit card or by check. The account owner can authorize someone else to make withdrawals through a power of attorney. Automatic withdrawals to an ABLE account can be set up to help pay recurring bills. And there's 4 different investment options. There's 4 different types of ABLE accounts that range from aggressive to conservative. And balances, this is a really important one, balances under $100,000 are excluded from the Social Security resource limit. So your Medicaid eligibility continues even if you have a lot of money in that account, as long as it's less than $100,000. And if the account balance exceeds the SSI resource limit temporarily, Social Security benefits can be suspended until the balance goes back down. So there's some information below here, excuse me, about the website for New York State ABLE accounts to get more information if you're interested. I should have said this. I'm going to be sharing my PowerPoint with Craig so he can send it out to anyone who is interested in it. Supplemental needs trusts are other ways to help people with a disability manage their money. The purpose is to enable people to preserve their eligibility for government benefits, mostly Medicaid and SSI, while also providing access to trust assets that can enhance their overall quality of life and can pay for things that aren't otherwise covered by Medicaid. There's certain requirements for having a supplemental needs trust. The beneficiary must have a disability. The trust must be discretionary, and that means that there is a trustee who decides when and how much money to dispense from the trust funds. The distribution of trust assets usually can't impair the beneficiary's eligibility for public benefits, such as it's not supposed to be used for buying food, clothing, shelter, or healthcare. And the trust needs to name a remainder beneficiary. And that kind of depends on what kind of trust it is. And I don't want to get into all the nitty gritties of trusts. It's not a specialty of mine. But if someone has particular questions about trusts, you can contact me at another time and I can try to refer you to someone who can help. There's something called a pooled trust, which is like a supplemental needs trust, but an agency manages it instead of an individual. You still have your personal account, but your money is pooled together with a lot of other people's money. So the company manages it and they make investments. Another way that people can help an individual manage their money is through the representative payee system through Social Security Administration. So a rep payee can either be a person or an organization. That person's appointed by the Social Security Administration, and their job is to help the person manage their Social Security benefits. The rep payee's main responsibility is to help pay that person's current and make plans for their future needs like food, shelter, clothing, dental, or medical care. The rep payee can then help save any of the leftover Social Security benefits at the end of the month in an account. Anyone can apply to be a rep payee, including a family member. The rep payee has a fiduciary obligation to act in the best interest of the person whose benefits they are managing. They have to keep a record of expenses, they have to keep receipts, and typically a rep payee can't charge for their services unless that's approved by Social Security. The other reason that people often seek 17A guardianships is because they want to help their loved one make medical decisions. There's a lot of different, less restrictive alternatives that can be put together to create an alternative to 17A guardianship for helping someone make medical decisions. One, I mentioned earlier, a simple HIPAA release. Sign a HIPAA release with your doctor. Tell your doctor who you want to be able to access your records and have a conversation with your medical providers about your health care. And these are things that you choose. Execute a healthcare proxy. There are forms through New York State to fill out, and it's a pretty simple form. But a healthcare proxy is a legal document that where an individual appoints an agent to make healthcare decisions if they become unable to make their own decisions. The individual can allow their agent to make some or all of their healthcare decisions, and they can also give written instructions to their agent about different situations and what they want to have happen in the future if different situations arise. It's important to know that healthcare proxies can be revoked at any time. I always mention this law. It's called Act Now. It was created in 2008, and the idea was to create a simplified healthcare proxy for people with individuals. And it was supposed to work sort of like supported decision making, where there would be a pilot program created by OPWDD, and it would create a simple form that would be accessible to people with disabilities and approved by stakeholders, by DOH, and by OPWDD. And the healthcare proxy form would have an Act Now box that a person could check, which would allow an agent to make their healthcare decisions at any time, even before the individual is found to lack capacity by a doctor. And there were certain rules that were supposed to be in place to prevent abuse of this Act Now healthcare proxy. But the reality is the pilot program never was started by OPWDD, so it really doesn't exist now. I always like to mention it because I love the idea of people asking the folks at OPWDD about this and whether this might be happening at some time in the future. In the last couple of years, we've heard rumblings that maybe OPWDD could be revisiting this project, and that's promising. But honestly, I haven't heard a lot about it recently, so I just don't know. But it would be really nice to have a healthcare proxy for a person that had that Act Now checked box so that a loved one could begin making those healthcare decisions now instead of later. There's other things. This is called the Family Healthcare Decisions Act. And this is a law that establishes the authority of a patient's family member or close friend to make medical treatment decisions for a patient. If the patient's in the hospital and they lack capacity, if there was no healthcare agent or healthcare proxy previously signed, and if they hadn't specified a preference for that particular decision before they went into the hospital. If there is no involved family member, then the surrogate decision-making committee kicks in. Surrogate committee, decision-making committee is a committee that makes important medical choices and end-of-life choices for a person who's in the hospital when you can no longer make them yourself. And this, again, comes into play if there's no healthcare proxy or no 17A guardian. And the surrogate decision-making committee is typically made up of volunteer panels, and they're really for people who are unable to consent to treatment and unable to assess the risk and benefits and alternatives to treatment. And this is really appointed by the Justice Center, and I include a link here at the bottom for some more information. A MOLST is a medical order for life-sustaining treatment, and that this is intended solely for end-of-life and critical medical situations. And these are medical orders that are signed by doctors, and they follow requirements that are set out in the law. And it requires a doctor to find that a person is incapacitated and unable to make healthcare decisions. And these are completed for people who have no guardian and no healthcare proxy, and there's not a person who's there who can make decisions on that person's behalf. And finally, there are rights of actively involved family members for people who live in OPWDD operated or certified residences such as IRAs. And basically, this ensures that a family member is involved in medical care and treatment for people who live in IRAs. Anytime professional medical treatment is proposed and informed consent is required, OPWDD or the provider agency has to ensure that the individual is given an appropriate explanation, that they obtain consent from that individual or from their surrogate if they're unable to provide the consent, unless it's a case of an absolute emergency treatment situation. If the person is lacking capacity, that informed consent can be obtained from a guardian, or it can be obtained from a spouse, a parent, an actively involved adult child, an adult sibling, an adult family member, all the way down the line to that surrogate decision-making committee. So a guardian is simply not needed to be able to make these kinds of medical decisions. Another alternative to 17A guardianship is simply Article 81 guardianship. Sometimes people do need a guardian, and Article 81 guardianships are less restrictive because under the law, they can be tailored to meet a person's needs. Article 81 guardianship isn't perfect, but the process has built-in protections for a person's rights that don't exist in 17A guardianship. So this chart kind of spells out a lot of the differences between 17A and 81. I don't really want to spend time on it because I want to make sure we have time to answer questions. But some big differences are that 81 guardianships are tailored to meet a person's needs. 81 guardianship, the person with a disability has to be present and participate in a hearing, which is not the case for a 17A guardianship before that's imposed. The petition has to allege facts that the person's unable to manage their needs, where in a 17A guardianship, the petition simply says that it's based on the diagnosis of a person and the fact that they have a developmental disability. And also, 81 guardianships require that the guardian come back to court and file a report in court every year. So the court follows that guardianship year after year after year and makes sure that things are going well for the guardianship and that the person living under guardianship is thriving and that the guardian is acting in accordance with that person's wishes. So I'm ready to take questions. This is my contact information. I am happy to have conversations with people after this presentation. In the future, if you want to get in touch. We also if you're in need of legal assistance and have legal questions, you can also get in touch with our intake department through this email address and just mail at drny.org. or by filling out a form on our website, which is just www.drny.org. So I'm going to stop sharing now so that I can see you, Craig, and happy to answer any questions that might be out there.
Okay, we have a few questions. I want to say, Kim, if you wanted to put your contact information back up there, you can. I've got a couple more slides, but they're very informal. So one thing I would ask everybody just to stick to the end, because we do have a QR code for a survey that we like people to take on the presentation. It'll provide feedback for Kim and for us for future member empowerment series webinars. So if you could do that, I'd appreciate it. But we'll get to the questions now. Kim, the first one was, how might 17A affect a client whose family wants them to move into a group home due to health concerns, but the individual does not want to move?
So if a person's living under 17A guardianship, their guardian can force them to move. If there is a guardianship in place.
Okay.
The guardian, under the law, the guardian is obligated to take into consideration the opinions of the person living under guardianship. But at the end, the person who has guardianship does have the authority to make that decision. And what I would say is that often guardianships are imposed because there's this sense that the guardian can make a better decision than the individual with a disability, but that's not how it's supposed to work. You know, there ought to be a recognition that there are differences in opinions, and that just because a person believes that they can make what they think of as the better decision for that individual doesn't mean that they ought to be the guardian.
Okay, we have an actual statement from the chat from Karen Hunt, who's one of our care coordinators. She said, I've experienced this. The OPWD provider agency would not accept placement of a person against their will.
Mm-hmm.
Sorry, that shifted, despite the guardian desiring the placement. So that sounds like it probably was a choice of the provider organization. They were making a conscientious decision, perhaps, on that. Kim, could that be right?
Yeah, I mean, I think that could be a situation where that provider agency respected the decision and the choice of the person with a disability. I mean, my perspective as an advocate for people, a legal advocate for people with disabilities, is that was the right choice to make. And sometimes those choices are made because a provider agency doesn't want to be in a situation where they're faced with an individual living in an IRA who doesn't want to be there
Right.
and isn't going to stay there, because living, having a 17A guardianship isn't going to prevent you from isn't going to prevent an individual from leaving a residence and just saying, I'm not staying here any longer. That's not, you can have guardianship, but you can't control the actions of that individual.
So let me ask a follow-up question to that. So if in this situation, the provider did accept the choice of the guardian and was aware the individual was not in favor of this, what recourse would someone like a care coordinator have to better advocate for that individual?
Well, for one, the care coordinator could talk to that individual, especially if they have this, they could talk to the individual and assess whether they think that individual actually needs a 17A guardianship. Because if you have a person who's saying they don't want to live in an IRA, that's a person who's able to voice their opinion and their position. And if a person is able to advocate for themselves and say what they want, that could very well be a person who doesn't need a 17A guardianship. Because again, 17A guardianship is not supposed to be there because you think you can make a better decision for an individual with a disability. That doesn't mean that that person needs a guardian. Plenty of us have and know people who don't have a disability, who don't make decisions that you might agree with. That doesn't mean that your decision is more valid than that person. The other thing, the other way to advocate is through the life plan process, and the recognition that a person has the right to state and have in their life plan what their own goals are, whether they have a guardian or not, and what their wishes are. And that life plan exists to be a voice and a plan for the person to receive the services that they want, whether they have a guardian or not.
Okay, I'm getting some out of the chat here because they're coming in. Okay, so this is kind of a loaded question, I guess, for you anyway, Kim. What age does a child typically need guardianship in place? Is it age 18?
Okay, so I'm going to turn the question around a little bit because it's my position. I'm just going to state it. Most people don't need a guardianship. There's an assumption that when a child with a disability turns 18, they need a guardianship, and it's an incorrect assumption. And judges now are routinely turning people away and directing them to us to look at less restrictive alternatives before a court will entertain a petition for guardianship. And that's really how it ought to be. A 17A guardianship cannot be imposed on a person who is under the age of 18.
Is there an agency that can assist with filling out the 17A guardianship application?
I have no idea. That's not,
Yeah,
that's not something that
that's
our
probably more of
agency
an
would
internal
participate
question,
in.
Myrna. So we'll try to get you the answer to that. I'm sure many of the care coordinators on here may have resources for that sort of thing. Are all counties in New York served by DRNY?
Yes, all counties. We have 3 different offices throughout the state. We're in Rochester, we are in Brooklyn, and we are in Albany, but we represent people throughout the state, every single county: North Country, New York City, Westchester, Southern Tier, Western New York, everywhere.
Great. And I don't know, Myrna, if you saw Karen's response, but in the Southern Tier, in tandem has someone that can assist with that. So thank you, Karen, for that. You touched on it. I don't know if it needs to go deeper than what you said, Kim, but if you can't expound on it, that's fine. Can you talk about the requirement of the court to ensure the least restrictive alternative when considering 17A guardianship? What does that look like?
Well, what it is supposed to look like is a hearing where the court examines what kind of supports a person has, whether they are formal or informal, and whether there's a way to achieve the goal of protecting that individual and helping them make decisions that are less restrictive than a plenary guardianship. The reality is, and we're seeing it less and less as there is an understanding and an acknowledgement that not everyone with a developmental disability needs a 17A guardianship. But historically, what often happened was a court would receive a petition and these certifications, and guardianships were often kind of rubber stamped because they're convenient for families to have, and sometimes for agencies to have, to be able to make decisions. But there's now this recognition that there shouldn't be an assumption that people with a disability automatically need a guardian. So often what I've seen is courts questioning petitioners for guardianship about what other alternatives they have looked at first before trying to obtain the guardianship.
So one of my goals, I got to tell you, as a mentor and a facilitator, is to get the word out, especially to our members, our families. Care coordinators are big messengers of this, and school districts are huge. But if you hear guardianship, you should be thinking supported decision making. So explore that. So
I
just a
absolutely
little
agree.
plug.
Yeah. And in the meantime, while we're in this kind of period of transition where OPWDD is installing this new agency that's going to be, facilitating the supported decision-making agreements, I am open, and I'm keeping a list of people, and this is at the request of OPWDD. If you are an individual or you know of an individual who's interested in supported decision making, but it's unavailable right now. It's going to be available again, but right now, momentarily, there's not an agency who can do this work right now, or who is doing this work right now. I'm keeping a list of contact information so that people don't get lost in the process and in the system here while we're waiting for the new agency. So feel free to reach out to me. And if you can't reach anyone at Supported Decision Making New York, and sometimes people can right now and sometimes they can't. I don't really know what their capacity is right now, but I do know that they're not assigning facilitators. But if you're interested in supported decision making, but you're kind of hitting a brick wall, feel free to shoot me an email, and I'll keep your contact information. And I'm passing that information on to OPWDD so that they can get in touch with people, or they can have the new agency get in touch with people when they're up and running.
Yeah, and if you're interested in just learning more about sport decision making and what it really looks like, you can contact me. I've talked to many people about it individually. I talk with members, families, providers, care coordinators. So please reach out. We're cutting it close. I'd really like to get to this last question. As related to informed consent and surrogate decision making, what is the measure of actively involved when it comes to a family member, or is there one?
I don't know that there is one, and I think that's a really great question. And I think it's a case by case basis, and it depends on the hospital. It depends on the providers. It might even depend on who's there at the nurse's desk at that moment where a person shows up and purports to be an actively involved family member. I don't know the answer to that. I don't know. I'm sorry.
I don't think I expected you to. I was kind of maybe hoping you would have some idea, but that's a tough one.
I'd like to
Actively
think that they
involved.
would ask some questions,
Sure.
and I mean, I think that it kind of intuitively, those care providers in the hospital are going to recognize whether a person is really invested and has knowledge and a relationship with their family member. I don't know though. I mean, I've seen
Yeah.
cases where, there's family issues for sure, and sometimes that clouds the whole situation.
I can tell you that internally, wear another hat, and I often see care coordinators faced with that, and I got to say our care coordination team is very good about kind of weighing that that
Figuring it
actively
out.
involved. So very pleased
Yeah.
with that. So Kim, I can't tell you how great this was. Thank you so much for coming.
Oh, you're very
You're
welcome.
a wealth of information and resources, so I really appreciate it. If everybody just could bear with me one more minute while I share the PowerPoint, and if you would take this brief survey, I'd sure appreciate it. Hopefully it's working. If it's not working, you're excused from taking it, obviously. So let me see here. There it is. And there you go. Oops, no, that's the wrong one. There we go. One more, I think. Okay, so if you scan that, it should take you to a survey. Just a few questions, but we'd sure appreciate the feedback. So thanks. And thanks everybody for attending. It was a great turnout. I was really pleased to see the number of people from the community and the number of care coordinators on this. Very exciting. So thanks for your time.